Okay, this is the second video over the First Amendment. The first one was on the freedom of speech, press, petition, and assembly. And this one's going to be just dealing with the freedom of religion. It's going to be outlining over several court cases and other limitations to the freedom. Then it's also going to get into some of the expansions of the freedom. This again is being a presentation given by Mrs. Miller, and she will outline over for you the different content. Make sure you're getting down all the information into your video sheets so you have this to study for your tests with them.
Freedom of religion involves the Establishment Clause, which prohibits the establishment of religion by the Congress. It guarantees separation of church and state. Freedom of religion also includes the Free Exercise Clause. The government cannot prohibit the exercise of religion. Congress shall make no law prohibiting the free exercise of religion. This is also known as the Religious Freedom Clause. When the roles of government and religion are intertwined, the result is usually bloodshed or oppression. The difference between Establishment Clause and Free Exercise Clause is the Establishment Clause limits the government in their ability to establish religion, while the Free Exercise Clause protects the people's ability to practice their religion. Pierce versus Society of Sisters in 1925. Oregon wanted to require all to attend public schools. The Society of Sisters sued for going against their freedom of religion, and the Society of Sisters won. The 14th Amendment was applied to the First Amendment, freedom of religion. Engle versus Vidal, 1962. In 1951, the New York State Board of Education approved a 22-word non-denominational prayer to recite in public schools every morning. The parents of 10 kids in the new Hyde Park schools objected the prayer. They filed in court seeking both of the prayer. A 6-1 vote in the court was in favor of the parents, and the court declared the prayer unconstitutional because this goes against the Establishment Act. Schools are not allowed to promote daily classroom prayer because it is unconstitutional. Stone versus Graham in 1980. Stone and other parents in Kentucky challenged a state law that enforced a copy of the Ten Commandments in every classroom. Graham was the superintendent. A 5-2 in favor of Stone and the parents was ruled, and it furthered the separation of church and state by removing religion from schools even more, which took the Ten Commandments out of school entirely. Wallace versus Jaffrey in 1985. This involved the decision on the issue of silent school prayer. Alabama law required teachers set aside 1 minute each morning for meditation or voluntary prayer. Ishmael Jaffrey was a parent of 3 children and was against the maintaining or allowing the maintenance of regular religious prayer services or other forms of religious observations. He claims that 2 of his children had teachers who led their class and sang certain prayers. Jaffrey's child repeatedly asked for prayers to stop, however, he was unsuccessful. Originally, the Southern Alabama Court allowed the practice and favored the defendants. However, the U.S. Supreme Court ruled 6-3 that Alabama law was unconstitutional. Once again, this pushes religion even further out of public schools. Santa Fe School versus Doe in 2000. It was a student-initiated prayer. Students were allowed to announce Christian prayers over the intercom at home football games. 2 sets of kids and their mothers, one Mormon and one Catholic, objected the practice and filed suit based off of the Establishment Act. They were anonymous and referred to as the Does. Court ruled these public prayers unconstitutional for on-school property at school-sponsored events over the school public address system by a speaker representing the student body under the supervision of school faculty and pursuant to a school policy that explicitly and implicitly encourages public prayer is public speech, not private. Students cannot initiate religion in schools. For example, I could not pray over the whole cross-country team. U.S. versus O'Brien in 1968. Criminal prohibition against burning a draft card did not violate the First Amendment rights or free speech. Paul O'Brien and 3 others burned their draft cards on the steps of the South Boston courthouse in front of a crowd. They did this in an attempt to persuade people to oppose the war. A 7-to-1 vote, 7 in favor of the U.S., saying this was unconstitutional, or was O'Brien was in the wrong. It convicted under a federal law that made the destruction or mutilation of draft cards a crime. In 1972, the court used part of the O'Brien case to void a law that prohibited picketing outside public schools that wasn't related to a labor dispute. It imposes a selective restriction on expressive conduct. Texas versus Johnson in 1989 supported Gregory Lee Johnson's act of flag burning through freedom of speech in the First Amendment. The court considered whether or not it was a matter of speech since the act was nonverbal. The decision was that under the circumstances, Johnson's burning of the flag constituted expressive conduct, permitting him to invoke the First Amendment. Prior to this case, there were prohibitions on destroying the American flag. The court decided to indicate these laws in 48 of the 50 states. Since then, Congress has considered a flag desecration amendment multiple times. The Lemon Test in 1971 from Lemon versus Kurtzman. The Lemon Test used to determine when law has effect of establishing religion. In order for a law to satisfy the First Amendment, it must have some secular or non-religious purpose, must neither promote or inhibit the practice of religion, and must not foster an excessive government entanglement with religion. If a law violates any of these principles, then it is under the Establishment Clause. Christmas controversy, which involved the separation of church and state, or Christmas censorship. In 1870, President Grant made Christmas a national holiday. In 1998, Ohio lawyer Richard Ganulin sued the federal government. He tried to remove Christmas from the federal holidays. The government endorsement of Christianity, violation of the Establishment Clause, is what he tried to prove. The lawsuit was then dismissed in about 1999. Can the government display religious holiday symbols? Possibly. This looks at the context of display and decides whether or not there is a religious message. For example, a Christmas tree, Santa Claus, and teddy bears, they are acceptable. However, a nativity scene that reads "Glory to God in the highest," that breaks the Establishment Clause. Critics of the case call the court's approach the 3 reindeer rule. Symbols that in large quantities can justify an otherwise religious display, such as reindeer, Santa Claus, elves, and big trees. Some schools require that music programs play only holiday tunes. Nothing can be related to religion.
Okay, and that takes us to the end of the presentation over the First Amendment, freedom of religion. And with that then, make sure you got everything down. If you need to go back over any of the videos, make sure you do that. And get all the questions answered over the 2 videos then.